This courtroom moment starts like many others, but within seconds, it turns into a complete showdown. A routine hearing quickly spirals out of control when a defendant begins challenging the authority of the court itself. Instead of answering questions, he argues jurisdiction, talks over the judge, and insists the legal system has no power over him. The tension in the room rises fast as Judge Simpson tries to keep the proceedings on track while the defendant refuses to follow even the most basic courtroom rules. What makes this case even more intense is the seriousness of the charges. The defendant isn't in court for something minor, he's facing drug possession and multiple counts related to resisting law enforcement. But instead of focusing on his defense, he repeatedly interrupts, uses unusual legal phrases, and claims the court has no authority over him. His behavior becomes so disruptive that the judge is forced to mute him just to continue speaking. You can feel the frustration building as the judge gives warning after warning, trying to maintain order in a situation that's clearly slipping away. Then comes the moment that changes everything. One final outburst that crosses the line and leads to an immediate and powerful response from the bench. This video captures what happens when courtroom procedure collides with defiance, and how quickly patience can run out when respect for the law disappears. Stay tuned, because this isn't just a hearing, it's a courtroom clash you have to see to believe.
Here today for a pretrial hearing in this case, and we are proceeding today by video conference and also in person. We are, or first let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Your Honor, Michael Dagger-Margosian for Mr. Lester.
All right, and Mr. Dagger-Margosian, where do we stand with Mr. Lester's case today?
Your Honor, at this point, I don't, there's a breakdown of attorney-client relationship. I can't move forward and represent Mr. Lester. I've without getting into the details, obviously those are privileged, but it's clear that Mr. Lester either needs to move forward pro se, and I can certainly be on standby, or I can conflict this out, but our office is not going to be able to represent Mr. Lester.
Yeah, I would like the ACLU to pour. I poured everything to the ACLU. They already have my file and the Civil Rights Commission.
Mr. Lester, I'm sorry, but the microphone at the jail is really bad. There's a bad echo there.
Can you hear me? Can you hear me now?
Yeah, so I can hear you. The issue is if you could talk not quite so loudly, because it's an echo in the room that causes the problem.
I'm moving the ACLU and the Civil Rights Commission already are on this. You can move my file to those. I have sent them my complaints. I've also got the failure to appear, what I was picked up for in the first place, was dismissed. And Mr. Bargosian is trying to move forward with a trial, and I'm not feeling that. I want to move for an immediate dismissal because I was harassed for 3 days, and they already have wind of this. There should be they should be asking for the body cams from August 2nd, as well as the 4th. I still haven't went over any evidence. So the Civil Rights Commission has my paperwork, and my affidavits rather, and the ACLU is on standby as well. I just rather for my whole file to go to them and let them represent them. Let them take a look at what's going on. I don't have any transcripts. I haven't talked to Mr. Margosian since then. I had to have the jail email the courts for a court date because I've been sitting here for so long. Like I said, the failure to appear got dismissed. That's what I was picked up for originally.
Okay, so Mr. Lester, you've been charged with possession of methamphetamine and 2 counts of assaulting, resisting, obstructing a police officer presented by the public defender's office, and they are requesting to withdraw as your attorney at this point. If that were to happen, another attorney would be assigned to you.
I just said the ACLU. I don't know what part of that nobody understands, but the ACLU is on standby as well as the Civil Rights Commission. I said it again. You can forward that all over there to them, and they'll take the case without no money. You know it like
all right.
I know.
So, Mr. Lester, those That is not an option that I have, to send this case over to the ACLU. If you want the ACLU.
I do though, because I do though, Cole. Let's get that understood. Now I have that opportunity to do that, and I'm requesting that on record.
Okay, you can request that, but the court is not in a position to do that. If you want someone else to represent.
Am, sir. That's what I'm trying to tell you. It's not simple as you just putting the case together and sending it to him. It's not even you. Mr. Margosian can do it. It's not even your office that needs to do it.
Mr. Lester, please don't interrupt me when I'm talking to you.
Right. Here we go.
All right. Right now, the public defender's office represents you.
No, they don't. He just said he didn't want to represent.
All right, Mr. Lester is off camera. I don't know whether he's still in the room.
I'm standing right here. I can hear everybody. I'm here as a third-party intervener and a special appearance.
All right, Mr. Lester, are you in agreement with Mr. Dagger Margosian's request to withdraw from your case?
That's on him. Like I said before, I wanted to go to the ACLU or the Civil Rights Commission. I'm going to say it again for the court of record. They are on standby. They already know about all of this. I shouldn't have never been picked up in the first place. I was harassed for 3 days. 3 days. And you have the transcripts right there in front of you when the officers admitted that they just wanted me. And it's in the police report.
Mr. Lester, I need a yes or no answer to the question of whether you are.
Again, that's on him.
Mr. Lester, I've muted your device, Mr. Lester, because you are being disruptive and you are not allowing this court process to continue. I'm going to give this one more opportunity. I'm going to unmute your device. I'm going to ask you the question. If you don't answer, or if you continue with this disruptive behavior, I am going to hold you in contempt and sentence you to 93 days in jail.
Very unprofessional.
Mr. Lester, are you in agreement or are you not in agreement with Mr. Dagger Margosian's request to withdraw as your attorney?
Well, if you please, yeah, I'm in agreement. If you please send that file over to the ACLU, please. I'm in agreement with that. Mr. Margosian, are you in agreement with you send that over to the ACLU, please?
Can I get like a contact information? I mean, I don't just send a file to
okay, yeah, but you know where the ACLU's office is. I can get that to you. Yes, no problem. We can go off screen. I can get that to you. I have it right here in front of me. No problem. No problem.
And if that for whatever reason, I mean, that's outside the normal.
Man, I'm not. It's as simple as name my rights have been violated. You know that. We're not going to keep going back and forth. I'm not doing it.
All right.
Mr. Lester, please stop. So Mr. Lester has consented to Mr. Dagger Margosian withdrawing as his attorney. If there's some arrangement for Mr. Dagger Margosian to send information to the ACLU, that is, the court has no control over whether he is going to do that, and the court has no authority to require him to do that.
And Your Honor,
what the court is required to do under this process is to provide for the appointment of a special public defender. If Mr. Lester can get the ACLU to represent him, then you need to make arrangements to do that. And if there's an appearance filed by the ACLU, then they are welcome to represent him. But as it stands now, he is without attorney, and the court will make the appropriate arrangements to have a special public defender appointed. If the ACLU wants to substitute in place of that person, they are welcome to do so.
Yeah. I also like for a PR bond. I've been sitting here almost 180 days. My bond is ridiculous. My family's not going to be able to pay that.
All right, I will adjourn this case to February 7th.
I'm requesting a bond, please, for the court of record.
Mr. Lester, let me do one thing at a time. You're constantly interrupting me.
I'm just tired, man. I'm tired. Mr.
Stop interrupting.
How did it, man?
Pretrial is adjourned to February 7th at 8:15 a.m. Mr. Lester has made a request for a personal recognizance bond. court has addressed the issue of bond with Mr. Lester numerous times previously. My decision on bond and reasons for it at this point have not changed.
Supposed to be professional.
Mr. Lester currently has a
Too expensive, sir. Too expensive.
Mr. Lester currently has a $5,000 cash or surety bond in this case, and that is appropriate, in my opinion, to assure his further appearances at this court. And so I'm going to deny the request for a personal recognizance bond.
That's crazy. Because I ain't white. Mr. Mark, go to
Mr. Lester. All right, you know what, Mr. Lester, stop.
No.
I muted your device, Mr. Lester. You have been warned repeatedly by me in this hearing as well as in other hearings. You are in contempt of this court as a result of your behavior here today. It's a sentence of the court that you served 93 days in the Lenawee County Jail. There's no further information that the court needs to find the contempt. It was directed in the presence of the court and after being warned numerous times. So, Mr. Lester, you can let the officer that's with you know that you are done with court for today. I will put the device in the waiting room until you are gone.
This courtroom hearing starts with the kind of tension you can feel before a single word is even spoken. The judge takes the bench expecting to handle what should be a routine matter, but it quickly becomes clear this is not going to be an ordinary day in court. Sitting before Judge Simpson is a defendant who has no intention of playing by the normal rules of the legal system. From the very beginning, the tone is off. Instead of calmly responding to the judge's questions, the defendant immediately starts challenging the court's authority. He insists he is not subject to the court's jurisdiction and uses strange legal phrases that sound official but don't actually follow real courtroom procedure. It's the kind of language often associated with people who believe the legal system doesn't apply to them. The judge attempts to maintain control, speaking in a measured and professional tone, but the defendant keeps interrupting. Every time the judge tries to explain what is happening, the defendant talks over him, claiming he is making a special appearance and does not consent to the proceedings. The courtroom atmosphere shifts from formal to confrontational within minutes. Things escalate when the defense attorney speaks up. In a calm but serious voice, the attorney asks the court for permission to withdraw from the case. The reason: a complete breakdown in communication with the client. The attorney explains that it has become impossible to effectively represent someone who refuses to cooperate or even acknowledge the court's authority. It's a rare and serious request, and it signals just how difficult the situation has become. The defendant reacts immediately, demanding that his legal file be sent to civil rights organizations, claiming they are ready to intervene. He speaks with confidence, as though he believes outside agencies are waiting to step in at any moment. The judge listens, but makes it clear that the court must proceed according to the law, not according to the defendant's personal beliefs. As the hearing continues, the judge outlines the charges. These are not minor issues. The defendant is facing accusations involving drug possession and multiple counts related to resisting or obstructing law enforcement officers. These are serious allegations that carry real consequences. Yet instead of focusing on his defense, the defendant remains fixated on arguing that the court has no power over him. The interruptions grow more frequent. The judge warns him again and again to stop speaking out of turn, but the warnings have little effect. Eventually, The judge has no choice but to have the defendant's microphone muted just to be able to finish a sentence. Even without the microphone, the defendant continues talking, shaking his head, visibly frustrated, convinced he is in the right. You can see the patience being tested. Judges are trained to remain calm, but there's only so much disruption a courtroom can tolerate. Each time the defendant refuses to follow simple instructions, the tension rises another level. Court staff sit alert, ready in case the situation escalates further. At one point, the discussion turns to bond. The defendant requests to be released on a personal recognizance bond, meaning he would not have to pay money upfront and would simply promise to return to court. The judge considers the request but ultimately denies it. Given the defendant's behavior and the nature of the charges, the judge decides a cash surety bond is necessary to ensure he returns for future hearings. That decision only fuels the defendant's anger. He begins speaking louder, more aggressively, insisting the process is unfair and illegitimate. The judge tries once more to explain that this is how the legal system works, that everyone in the courtroom must follow the same procedures. But the defendant is no longer listening. The courtroom feels like it's balancing on a knife's edge. Every word from the bench is met with resistance. Every instruction is challenged. The judge issues repeated warnings about courtroom conduct, making it clear that continued disruption could lead to serious consequences. Then comes the moment that changes everything. Frustrated and visibly upset, the defendant directs a personal insult at the judge, accusing him of bias and using language that crosses a clear line. The atmosphere in the room shifts instantly. What was tense becomes electric. The judge's demeanor hardens. Up until now, he has shown remarkable restraint, giving the defendant chance after chance to correct his behavior. But direct insults and accusations aimed at the court cannot be ignored. Maintaining respect and order is not just about courtesy, it's essential for the justice system to function. In a firm, controlled voice, the judge explains that the defendant's behavior constitutes contempt of court. Contempt is not about disagreement. It's about actions that disrupt proceedings or show open disrespect for the authority of the court. The judge makes it clear that multiple warnings were given and ignored. The courtroom goes quiet as the judge announces the consequence, a jail sentence for contempt. It's immediate, it's serious, and it's meant to send a message that there are limits to what the court will tolerate. The defendant reacts with disbelief, still insisting he has done nothing wrong, still arguing even as deputies move closer. What started as a hearing about criminal charges has now turned into a powerful example of how quickly things can spiral when someone refuses to follow basic courtroom rules. The judge didn't seek confrontation, but he also couldn't allow the courtroom to descend into chaos. Throughout the entire exchange, you see two completely different views of the legal system colliding. On one side, a judge trying to follow procedure and maintain order. On the other, a defendant who fundamentally rejects the system's legitimacy. There is no middle ground, and that's what makes the situation so explosive. By the time the hearing ends, the outcome is about more than just the original charges. It's about the authority of the court, the importance of respect in legal proceedings, and the reality that personal beliefs don't override the law inside a courtroom. This hearing serves as a reminder that courtrooms operate on structure, rules, and mutual respect. When those foundations are challenged at every turn, the system has mechanisms to respond, and sometimes those responses are swift and severe. The entire exchange is tense, uncomfortable, and unforgettable to watch. It shows how quickly patience can wear thin, how firm a judge must be to maintain control, and how serious the consequences can become when someone refuses to recognize the authority of the court standing right in front of them.